And the topic for today's presentation is to LLC or not to LLC, that is the question. And obviously that's a play on the famous soliloquy from Hamlet, but it also is, I guess, the start of a historical discussion of how we got to where we are now with the formation of legal entities. In Shakespeare's time, if you wanted to start your own business, pretty much all you had to do was take a handwritten sign and nail it to the outside of your hut, and you were in business selling, meat or bread or whatever. Frankly, you can still do business that way today. You are perfectly able to open a business and sign all the contracts in your own name and to do business as, Sam's Meat Shop or whatever. And that's a perfectly legal way to conduct business as long as you get the proper licensing and all that. Now the downside of doing that proved to be that you had no protection in terms of your personal assets if you conducted business as a DBA, because if the company signed to buy a supply of wheat for their bread manufacturing and you couldn't pay for it, the creditors would come looking at your personal assets, your house, your car, whatever, to collect on your unpaid bill. And so over time, people realized that there was a downside of engaging in business personally, because you were risking not only the money you invested in the business, you were risking all of your other assets as well. And so the next step in evolution, if you will, was what if it's not just you that wants to open this bread shop or this mead brewery? You've got a neighbor who has a cow that's really going to be handy in producing the milk to make your bread. And so you go into business together. And that's sort of the origin of a partnership. And a partnership, basically, like a sole proprietorship, is a situation where while you now have to figure out how you're going to divide up the profits and divide up the losses, each of those partners is also fully liable for the business's obligations. So again, while it may give you more flexibility in banding together to have a stronger business, it gives you no protection in terms of safeguarding your personal assets from your business creditors. So after passing several centuries between the time of Shakespeare and now, they developed a corporation. And a corporation is regarded at law as a separate legal entity, meaning it can enter into contracts and it can conduct business just as if it was a human being doing business. And more importantly, if the corporation signs a contract, and if you don't do certain stupid things that Phil will discuss later, and can't pay its creditors, the creditors are limited to looking to the assets of the corporation in terms of satisfying your business debt. And that's the principal reason people form corporations, is to provide this layer of legal protection between the obligations of their business and their personal assets. And so corporations were around quite a while, but they had certain downside limitations. You had certain filing obligations. You had to file annual reports with the Arizona Corporation Commission. You had to file a separate tax return for your corporation. It is treated in pretty much in every respect as if it were a separate legal person. And so while it gave you this huge advantage of having an insulating layer between you and your business creditors, it also had downside expenses and inconvenience. And that's what led to the development of a limited liability company. Now, a limited liability company was designed to sort of be a hybrid between old corporation law and partnership law. And it gives you, hopefully, the best of both worlds in that, like a corporation, the owners of the company have personal liability protection from business debt, assuming they do things correctly. The advantage over a corporation is that limited liability companies are not required to file annual reports with the Arizona Corporation Commission, meaning you don't have the expense of having that make those filings or have them prepared for your company. There are instances where limited liability companies don't even have to file a separate tax return, meaning you can save on the accountant expenses of having to do a separate return for your business. They also have a greater flexibility in terms of tax treatment, as Phil's going to tell you in a little bit. You're not limited to simply one or two choices in terms of what your tax treatment of your company's profits would be. There's also some language differences. People are generally familiar with the jargon used in connection with a corporation, in that the owners of the corporation are the stockholders or the shareholders, and the manager and the corporation is typically managed at the highest level by a board of directors, and then they have officers such as president and vice president, secretary, and treasurer. The language in the limited liability company has similar concepts, but they call them by different names. The owners of a limited liability company are not called shareholders, they're called members. The person who runs the limited liability company generally is called a manager rather than a director or a president. They also have a difference with regard to the organizational and operating documents. You form a corporation by filing articles of incorporation. You form a limited liability company by filing articles of organization. You determine how your company is going to be managed and run in a corporation by enacting bylaws. If you have a limited liability company, you typically have what's known as an operating agreement. But notwithstanding the difference in terminology, these documents typically work very similar to one another. Now, the other thing that I'm going to discuss, at least initially, is there is another difference in that there are two ways that you can have your limited liability company managed. The first one is, as I indicated, you can have an individual or group of individuals designated as managers. And these managers don't even have to have an ownership interest in the company. They could simply be someone that the actual owners, the members, have hired to manage their company. Or they can be one or more of the owners themselves will be the manager. The other way that you can set up a limited liability company is, in terms of management, is to have it managed as a member-managed organization in which the only person in control of how the company operates or who can sign contracts that bind the company are the members themselves. And that's something you determine at the time you form the company.
Yeah, we advertise this as the when, why, and how to form a legal entity for your business. We're lying. Why and when really are the same things. What we're going to cover is what, which you just heard, how, which I'll talk about now, and then why at the end. So, how do you form an LLC? Very easy. You hire us, and then Sonora forms your LLC, and that's really all you need to know. So if you came here today to find that out, you can go home now. That's really all you need to know. Joe's discussion about the liability protection is something that, if you're not concerned about it now, you might be at some point. In the 70s and 80s, Sears accounted for something like 1.5% of the gross domestic product. If you pick up the Wall Street Journal over there, you'll see a story on the front page about how it's going into bankruptcy and is going to dissolve and go away. So in a period of 40 or 50 years, the largest company in the world is going out of business. That's a good reason to have a corporation. is because Sears's liabilities, and they're going to be people that get hurt, are not the owner's problem. Well, it's the owner's problem because their stock in Sears isn't going to be worth anything. Okay, how do you form an LLC? The first thing is you file articles of organization. It's about 2 pages. You only have to, under Arizona statutes, and by the way, we're talking about Arizona statutes. Every state has different limited liability company statutes. There are a lot of similarities, but then there are quite a few differences too. Countries around the world have limited liability company statutes. Some of them are very similar, some of them got some interesting tweaks to them. So you file these articles of organization, you pay a fee, you pay to expedite it unless you want, unless getting your documents back in 4 months is okay with you. And the Corporation Commission takes them, they'll stamp them, okay, we have yours, and then sometime later, and this time varies quite a bit, they'll send them back to you and say, okay, it's approved. What they're looking for is whether you've filled out the articles of organization correctly. It's pretty hard to screw up. But you file these articles, you then have to publish them in a newspaper. Again, that's something we take care of, but you can do it yourself. And you got an entity. Now you have an LLC. You've got an empty box, basically. The next step most people take is they prepare what's called an operating agreement. And all an operating agreement really is supposed to be an agreement among the members and managers about how the company's run. Well, you can have a single member LLC. So I form an LLC, I'm the single member. Who am I agreeing with when I adopt this operating agreement? Well, really nobody. But I can tell you, if I go over to Wells Fargo and try to open a bank account, they're going to want to see an operating agreement. So I prepare a 2-page operating agreement that says, I'm agreeing with myself that these are the terms of our operating agreement, and then Wells Fargo will give me a bank account. Now, the operating agreement, when you've got more than one person involved, those are the rules of the road. Those tell the people involved in the company how it's run, who can make what decisions, who can borrow, what the when capital is going to get raised, who's going to do what. So the way when people try to shortcut this and do it themselves is getting the articles filed is pretty simple. Not a lot of screw-ups there. The biggest mistake I see is when people decide they're either not going to have an operating agreement or try to do the operating agreement themselves, where they've got 3 people. I've got some people working with right now, 4 buddies got together and they formed this company and they're off and running and they have no operating agreement. And now they don't get along. And 2 of them want to kick out the other one. And there's just no rules. Well, excuse me, there are rules. There's the statute. But it doesn't cover all the things they should have thought because they didn't want to spend any money up front thinking about these issues.
Time has seemingly caused an evolution in the types of legal organizations that people form. When I first started forming entities maybe 25 years ago, I have to say that over half of the entities that I formed were corporations, classic corporations, because people had heard about them, they were familiar with them, and that's what they wanted. In the last 5 years, I would say I've maybe less than 10% of the entities I formed are corporations, and over 90% are limited liability companies. And there are some reasons for that. One of the things that really goes into that is that you get all of the benefits as a investor in a limited liability company that you get in a corporation in terms of protecting your personal assets from business creditors. On the other hand, it is a lot simpler. Corporations typically are required to have at least 1 annual meeting of the shareholders and the board of directors and to keep minutes on file to show that they're actively maintaining the entity. Limited liability companies, you can never meet if you don't want to. You can put it in your operating agreement that you meet only when somebody, when a member requests a meeting, so that there's no ongoing, need for regular meetings to cover routine business matters. As we said, you can structure it so that either you have a professional manager running your business, or you can do it yourself as both a member and a manager. Or if it's like 2 of you and you're good friends and neither one of you trusts one another, you can operate it as a member managed, where each of you has a 50% vote, and then work out some sort of a tiebreaker when inevitably you disagree with one another. It's also an advantage in that, as I said before, you don't have to file the annual reports, and it also can be an advantage in terms of the amount of money you spend on accounting, because as I pointed out, corporations typically have to file a separate tax return each year with the federal and state government, whereas a limited liability company, in certain instances, they do not. And one of those instances, or the only one I really am familiar with, is if you elect what's known as disregarded entity status when you file your company. And that can only happen if you have either just a single tax, individual taxpayer, maybe spouses who file jointly on their tax returns. But in that instance, instead of filing a separate tax return for your business, you simply report the business's profits or losses on your personal tax returns under, I think, Schedule C, business income. And because LLCs have all of the upsides in terms of liability protection of a corporation, and they have several advantages in addition to that over a corporation, then you have to ask yourself, why would I ever choose a corporation over a limited liability company? And the only answer I've been able to come up with is it depends on your anticipated vision for your business. If you're always going to be a small or medium business with just a handful of owners, then there's really no reason to pick a corporation, because you can do everything with a limited liability company that you can do with a corporation at that size. The one exception is if you have visions of someday coming up with the next great widget and patenting it and selling millions and millions of them and doing an initial public offering and selling your stock to the general public. In that instance, you're better off with a corporation because it's more flexible in terms of having the ability to change ownership, shareholder interests easily, as opposed to bringing members in and out of the company each time there's a transaction. So that's about the only situation where I think a corporation has a clear advantage over an LLC, and that probably explains why over 90% of the people that I deal with these days choose the LLC option over the corporate option.
The Internal Revenue Code has a set of sections that deal with how you pay taxes on your personal income. There's a different set of the chapter of the Internal Revenue Code that taxes partnerships. There's a separate chapter of the Internal Revenue Code that taxes corporations. The words limited liability company in that order appear nowhere in the Internal Revenue Code. So the IRS has no way of taxing limited liability companies. Now, that last part is not quite true. It is true that the words don't appear in the tax code. And the first state to have LLC legislation was Wyoming, like in the adopted statute in the 70s. Nobody used it because nobody knew how it was going to get taxed. There was no certainty over if you formed a Wyoming LLC what the IRS was going to think that is. So if you thought it was a partnership and the IRS thought it was a corporation, you'd get a really bad surprise. Well, in the early 90s, the IRS finally said, okay, here's the deal. If you have one owner, one member of a limited liability company, it can be taxed as either a disregarded entity, you put it on your personal tax return. You could have it taxed as a corporation. And in fact, you could have it taxed as either what's called a C corporation or an S corporation. Take your pick. Tell us which one you want. You have those three. Here's a one-page form. Tell us which one you want, and that's how we'll tax you. And if you have you have at least two members, owners of this, well, it can't be a disregarded entity anymore, but it can be a partnership. It can be a S corporation, or it can be a C corporation. Take your pick. Tell us which one you want. That's the way we'll tax it. And so LLCs then became very popular because you got all the benefits, the flexibility, the liability shield, And whichever taxation scheme you fit into, you pick that one. Now there are some additional requirements for an S corporation. You can't have entities as owners, you can't have foreign people as owners, you can only have so many owners. But assuming you fit those things, you just file a form. You say, this is how I want to be taxed, so off we go. Now, which one of those you pick very much depends on exactly what the business is going to be doing. So for a long time, a lot of people were picking S corporation status because what they could do if the company was going to make, let's say, $100,000, we'll keep the math round, and it's my LLC, and I'm going to be performing services for the LLC. I could pay myself a salary of, say, 40. Now you get all sorts of employment taxes on that, FICA, federal unemployment, state unemployment, those sorts of things, Medicare tax. And so I'd get $40,000 in wages, but $60,000 in profits. And there's no, at least historically hadn't been, the self-employment taxes on the profits. So you could save some in taxes by splitting what was really one enterprise's income to the owner into different pieces so that you paid less taxes on that. Now that's gotten more complicated over the years, and it depends on whether you are the only member, whether you materially participate in the activity. So get an accountant. If you're going to start an LLC, go to the accountant, say, how do you want to do this for tax purposes? And they will have a discussion with you and say, pick S corporation treatment, take partnership treatment. We'll do it as a disregarded entity. One reason people would end up in partnership taxation is in partnership taxation, you can own 51% of the company, which would give you, for a lot of purposes, control, but take 80% of the profits. So you can split up ownership, you can have variance in between ownership and voting control. And that's handy. An S corporation, basically, if it's going to make a profit, the profit gets distributed pro rata among the owners, and you can't change that. Partnerships, and this is not unusual for real estate deals, may say, okay, the first, X number of dollars in profit gets allocated to you, then some profit gets allocated to me, and then after that we split it in different percentages. So you can be very flexible under the partnership tax regime with not only how income gets allocated, but also how cash gets distributed. Not true in an S corporation as much. The last factor sometimes is people don't want to file extra tax returns. Now, you have to ask yourself, if you have to give your accountant all the books and records, or a certain set of books and records to put it on your Schedule C, is it really that much more costly to put it on a 1065 or an 1120S, namely a separate tax return? They're still taking all the same revenue, the same expenses, looking at the same deductions, amortization, all those sorts of things. So filing the separate tax return really shouldn't be a big driver of the issue. Yeah, it's kind of a pain. It's got a separate deadline. It's got an earlier deadline. Maybe you don't want to manage that too much, but it's not really the cost of that that's the choice. So depending upon what your business model is. If your business model is generally performing services, those tend to be S corporations. Are you going to raise money from third parties? And are they going to want their money back out before you get any money out? More typical of a real estate deal. If that's the case, you're more likely to end up in a partnership regime. The IRS has certain defaults. So if it's a single member entity, it defaults to a disregarded entity. If it's two or more and you don't check the box, you get a partnership. But you can pick, you've got plenty of time to pick, but they have certain default regimes. So if it's a non-US entity, it defaults to corporation status, which can be nasty for people if they're not aware of it.
let's pretend now that you've decided that it's a pretty nifty idea to form some kind of an entity, an LLC, let's say, to protect your personal assets from your business obligations. Now the next question is, having made that decision, how do you screw it up? And believe me,
Yeah, it happens.
it happens, and it happens a lot.
And we're glad for that because we get hired that.
And I have a bankruptcy partner sitting over here that'd be happy to, give you his business card if you decide that you want to do it yourself and you don't really know what you're doing. And there are a number of ways. Some of them are obvious, some of them are less obvious. For example, the obvious way is you sign a contract in the name of your limited liability company, and you do it properly. We'll talk about what that entails. But then the person says, well, I want you to sign down here where you're personally guaranteeing the obligation. Well, obviously, if you have to, you got to do what you got to do. But every time you sign a personal guarantee, you're basically rendering the value of your LLC as worthless, because the whole point of doing business through an LLC is to protect your personal assets from your business obligations. And if you're personally guaranteeing the LLC's promissory note to a lender, you are defeating that purpose, because now you are exposing your personal assets to a business obligation. So that's the most obvious way that you can render the LLC worthless for yourself.
Yeah, we just cover the way you sign it is for anything that the company's doing, you put down the name of the company, by, then you can sign there, and then after it you put either member or manager, so that whoever you're dealing with knows they're dealing with an entity. Now, we had some people actually yesterday who hired a company to file a mechanics lien for them. They went out and got recorded, and I don't know what they were thinking, but they put John Doe, DBA, something contracting LLC. Well, who is that? That's got both names, but it gives no indication of who really is the person filing the lien, because John Doe isn't just doing business as the LLC, it's the LLC doing business as the LLC, and they got it completely screwed up, and actually may result in liability for the owner.
Just to reemphasize what Phil is saying, is on a signature block where you are intending to sign on behalf of your entity, it's basically some requirements. One, the signing party has to be identified as the company, not as your individual name, even though you're signing. Secondly, you have to indicate the representative capacity in which you are signing. In other words, you just can't, sign, have a contract that's between ABC Corp or ABC LLC and the vendor, and then at the bottom you just sign it, John Smith. You have to, basically have ABC LLC by John Smith to indicate you are doing it on behalf of ABC LLC, not yourself individually. And then finally, it's helpful and probably, if not necessary, certainly helpful to indicate below your signature line what your representative capacity is, namely its manager or its member, so that you clearly define that you are not signing it or intending to sign it in your personal capacity, but are instead simply signing it as an agent or representative of ABC LLC. Another one, which is, it requires more dedicated, screw-ups to get
Persistence.
you to. Persistence. You have to persistently do things wrong to get to this, but there is a concept at law called the alter ego theory. So, you do it right, you sign in the name of ABC LLC by its manager, but you never get around to setting up a separate bank account for ABC LLC. You operate it out of your personal bank account. You don't keep clear books and records. You need some groceries on Friday, so you just write a check or use a debit card on your company's account instead of a separate personal account. And you basically proceed to treat the company's finances and bank account as your personal finances and bank account. And if you do that persistently enough, as Phil said, you can ultimately create a situation where your business creditor can go to court and say, look, there was such a commingling of the assets and identity of the owner with the company that they should no longer be treated as two separate entities, but should be sort of merged into one single entity. And that means that both your company and you could be held liable for what you thought was clearly a business obligation. So there are like operating instructions. When our firm forms a limited liability company for a client, in addition to making sure that the articles are filed correctly, that they are published as they're supposed to, and that we have prepared an operating agreement that is appropriate for your particular circumstance, we also give you kind of like an owner's manual. You buy a car, you get like a 100-page manual in the glove box that tells you how to turn on the windshield wipers and so forth. We provide something similar with regard to limited liability companies, in that we basically provide a list of what you need to do in terms of setting up a separate business account for the company, how you sign documents, and how you go about maintaining the separate legal existence of that LLC, so that you don't end up years later, when your company's grown and had incurred bigger debts and has more value, that someday some creditor comes looking to your personal assets to satisfy a debt.
You just got to remember there are rules and play by them. It's not, the owner's manual isn't, like Joe says, 100 pages, but it happens a lot more frequently than we'd like to believe. That people just, they forget that the company is a separate thing from them. And you know, the dry cleaning bill comes out of the company bank account. That's not good.
There are also certain ways that you can end up having your company administratively dissolved by the Corporation Commission. It's harder to do if you own a limited liability company than a corporation, but trust me, it's still possible. One of the things that you are required to do when you form a limited liability company is to designate someone or some other entity to be the statutory agent for your company. And a statutory agent is nothing more than a fancy word for somebody who can be responsible for receiving like lawsuits or other official papers on behalf of the entity. And so let's say you have your cousin Fred, you know, agree to be a statutory agent for your company, and then Fred decides, you know, a couple years later he's not really into that, so he files a document with the Corporation Commission resigning as your company's statutory agent. If you don't do anything about replacing him, eventually the Corporation Commission will administratively dissolve your company because it no longer has a valid statutory agent. There's also other things that you have to advise the Corporation Commission of with regard to the ongoing changes in your company. You have to advise it, like if you are operating your limited liability company out of the back room of your house, you would put down your home address as the official business address of your company. But let's say then things go well and you either come here and start operating your business out of this office, or you even build your own high-rise skyscraper and put your company's name on top and operate out of the top 30 floors of the building. You put that structure's address as the official business address of your business. But whenever you change the physical location of your business, you need to notify the Corporation Commission of that by filing a notice of change of address form. And then the other thing that you have to do is if you have a change in ownership, and it's kind of limited in that minor changes, like if you give your nephew a 5% interest in your company, probably don't have to do anything because you still own 95% and your cousin owns, or your nephew owns 5%, so that's not really something you have to file. But let's say that there's two of you and you're already listed as owners with the Corporation Commission, and you bring in a third partner as an equal partner. Now you got 3 people, each of whom owes 33 1/3%. You have to update your paperwork with the Corporation Commission to now reflect that there is a third person who owns at 20% or more interest in your company. And so it's the 20% threshold that you have to be aware of. And if you either have someone who becomes a 20% or more owner, or someone who was, who no longer is, then you need to update that so that what's on file at the Corporation Commission only reflects those individuals or entities who own a 20% or more interest in the company.
My favorite topic, and that is what generates a lot of business for us, which is people who decide to go into business with either a relative or a friend, where each of them owns 50%. Does that happen very often, Joe?
All the time.
And how does that end up?
Badly for both of them, actually.
And why?
Because there's no effective tiebreaker unless they've built an operating agreement that has a way to break deadlocks between the 2 owners. If each owner has a 50% vote and you need a majority of the members to either take an action or stop taking an action on behalf of the company, and you got one who says yes and the other one who says no, how do you break that deadlock?
So what happens then? What happens in deadlock cases?
The one who is really unhappy can go to court, or you don't actually can go to court, and you can get what's known as a judicial solution. Basically, you go to court and file and say, like, the management of this company is hopelessly deadlocked, and therefore the company is no longer able to conduct business, as they anticipated. And if the evidence supports that, the court will ultimately issue an order saying that the company can't go on with this deadlock, and it is therefore dissolved. In fact, I don't know if you're familiar with the old George Orwell novel, Animal Farm, where the theory was that all animals are created equal, but some animals are more equal than others. But that's kind of the idea. Is you could basically have, even though you're 50-50 owners, you could basically have one of them designated as the company's manager, and then basically as the manager, you provide that it takes a 51% vote to remove him, so unless he votes to remove himself, that guy is always going to call the shots. Or you can have a trusted intermediary. Let's say your 2 brothers are going to business together and you each got 50%. And if you're getting a deadlock about what to do, maybe you'd have your dad have the tie-breaking vote if you can't agree. Just a mechanism that allows you to resolve this situation where equal owners are on opposite sides of a business decision.
People go into these businesses and they start up a new business, everybody's excited and they got a lot of interest in it, and they plan for how everything's going to go right. What they don't plan is for how things are going to go wrong. And that's what we see, of course, is all the ones that go wrong. So you have 2 owners and one of them wants to expand and the other one doesn't. Well, expanding is going to take more money. Well, where's that money going to come from? Can you force them to put up money? The operating agreement can't say yes. Sometimes it says no. You have 2 owners or 3 owners or 4 owners and they want to bring in a new member. Operating agreement can say that can happen without anybody's consent, or it can say it requires everybody's consent, or 51% or 80%. Operating agreement can set the rules on that. I have my 20% of an LLC and I want to sell it. Can I do that? Well, if they're shares of stock, normally I can. But it's an LLC, depends on what it says in the operating agreement. Maybe I can sell it, maybe I can't sell it. Typically it's locked up, so you can't sell it and admit new. Maybe sell it, but maybe only really sell part of it, a certain bundle of rights.
What happens if one of the members is married and gets a divorce, Arizona being a community property state?
Yeah, then you have the divorce judge saying, well, your 20% gets split 10 and 10. Well, great. Now I'm partnered with a spouse that I didn't elect to go into business with. I mean, I don't even like him or her. So you can provide the operating agreement, though, a way of dealing with that problem. Yeah.
Well, for the community property, though, if you have a business entity, can't you address that up front by saying that one is exempt when you do the deed originally, that it's conveyance in sole and separate versus doing it automatically?
Well,
Doesn't that
it's-
prevent that?
I think I understand what you're saying. It's not a deed per se, and you're right. The way to deal with it is to deal with it up front. A lot of times what people will do, particularly if it's, there's significant money involved in this business, is they will require all of their married members to have their spouses sign a spousal consent form, and then there will be provisions in the operating agreement that talk about what happens. For example, it may be an agreement that the non-member spouse agrees that she will not take the actual membership interest, but will instead be given financial value in other assets equal to her half interest in that membership interest.
Yeah, you can deal with it in the operating agreement, but if everybody's excited about starting a new pizza place, then they're not thinking about, well, all the different ways it can go wrong. So it can be dealt with up front. Raising money, that sometimes is a big issue. Who's got to put up more money? Where's it going to come from? And does it change the percentage interest when other people put up money? Who can borrow money? How much money can they borrow? How far can one person put the company in debt? Again, something that should be dealt with up front.
One member gets hit by a truck and killed. What do you do?
Yeah, where does
Does
go?
do his beneficiary or his offspring now become the member? What happens to his interest if he died? These are all things that you can deal with in the operating
I
agreement.
did have a question. In your example of operating an LLC out of your home, if your attorney formed your LLC and you use that, he's your statutory or she your statutory agent, use that address, you still have to let the Corporation Commission know your home address as the address
Basically,
of
all they care about
operations,
is the official business address of the company itself. That's what they want to know: is where does the company
Principal
do
place of
business?
business.
or could that be your statutory agent's, your attorney?
If they'll
Office
allow
or-
you to do it. The problem with that is if you're telling the corporation the principal place of business is your lawyer's office, and you're not doing any business at your lawyer's office, you're not really telling them the truth.
Okay.
So if you want to keep your home address out of it, it can be difficult. Snora, correct me if I'm wrong, they're still not taking P.O. boxes for that, are they? No. Yeah, you got to have a physical address, and you can't just put, and they've gotten tuned into this for like the private mailboxes, it'll be a street address, but then it'll be like PMB 602-833, which means it's Suite 602, Box 8. That they now reject those.
So you really need to use your place of business.
A physical address.
Yeah, a physical address. If you're doing business in Arizona, theoretically, you have a principal place of business in Arizona, and that's what they want.
And that it doesn't have to be just the only thing that goes on there. Like if you are working here, at Workuity, and this is your principal place of business, you can list this address, I guess, as your principal place of business.
You could.
Physical address.
Any questions? Oh, we've done such a wonderful job. Nobody has any questions at all.
Well, actually, I want to ask one. If you, I'll take his.
I was just wondering if you could use an LLC to protect your assets.
Yeah,
Yes.
principally
The
that's
short answer is yes.
yes. Yeah, just follow the rules. Just operate it like a company.
Okay.
Go
I have a
ahead.
question actually on that one. When you use the line that the bank says, and you will personally guarantee this, would you just cross that out and just put a smiley there? Or like,
Sure.
how do you get around that one?
Well,
Like,
it's like every business negotiation. I mean, banks, are simply doing a negotiation, but they're presenting their form document and saying, you want the loan, you got to sign what we say you got to sign. And then it's a matter of, all negotiations are a matter of power and leverage, There's an old joke that says if you owe a bank $10,000 and can't pay it back, you've got a problem. You owe a bank $10 million and can't pay it back, the bank's got a problem. And so if you have, if they want you as a customer, and the only way they can get you as a customer is, if they agree to waive the personal guarantee or to modify it and put a cap on it or something like that, they'll do that. But they're not going to volunteer that, and most people are not in that position of power versus the bank, because they really want to borrow the money, and the bank has got 10 other people waiting in line to borrow the money if you don't. So it's not, you're not in an equal bargaining position. But on the other hand, if you're talking about you got a vendor who you get your paper products from, and you sign invoices on behalf of your business to buy those paper products, most of them are not going to demand that you personally guarantee the company's obligation to pay for the paper. So there are or if you hire an employee to work for your business, and then times get tough and the business can't afford to pay the employee what it has agreed to pay, employees don't normally ask their boss for a personal guarantee of their salary. So it's all a matter of the particular transaction, who has the bargaining power. You never want to volunteer, you always want to take a shot at not signing a guarantee, but then ultimately you're going to have to make an informed business decision. Is it more important to me to protect my personal assets, or is it more important to me to get this loan so I can do whatever it is I want to do in a business standpoint? So it's whatever you can negotiate.
Small business starting out, the bank's not going to lend you the money without the guarantee.
Oh yeah, I know.
But at least what you've done is narrowed down the group of creditors. You haven't gotten out of personal liability for all debts, but you've narrowed it down to certain.
And I can tell you from personal experience, once you get to certain levels, you can greatly reduce, if not eliminate, the personal guarantee obligation. After a period of time, if you get enough financial clout, you might get like a pro rata guarantee rather than a joint and several guarantee, meaning you're only liable for your 10% of the company's debt rather than all 10 of you are liable for 100% of it. So there's things you can do when you get more bargaining strength. And in the meantime, like I say, it never hurts to ask. Yeah.
When a person is starting a business and making the decision to form an LLC, you were talking earlier about if you have long-term thinking about shareholders and things, but is there any liability protection difference between a corporation and an LLC?
If they're done correctly,
starting a business?
if they're done correctly, the answer to your question is no.
Okay.
Yeah, and here's the other thing about LLCs, more modern statutes, is you can start out operating as an LLC, and if you decide to go public, you can change the entity to a corporation. So start out as an LLC. There's really no reason to start as a corporation, even if your dreams are to be the next Amazon.
Actually, you can go both ways.
Yeah, you can go both ways. Don't know why you would, but you could.
One thing that you might want to talk about is obviously, if you own stock in a corporation, that's an asset that you personally own. Same is true of a membership interest in a limited liability company. If you own 25% of a limited liability company, you got 25% membership interest. That's property. Can your personal creditor, someone that you borrowed money to buy yourself a car and then you can't pay it back, can that lender get to your interest in the limited liability company? Can he get to the distribution of monies that comes to you from that limited liability company? Take it away, Phil.
Arizona's in a minority of states on this, by the way. Last time I looked, there was only 6 of them. If somebody gets a judgment against you and you own stock in a corporation, there's a process called garnishment. Probably takes 6 weeks, beginning to end. They end up selling your stock, or the sheriff ends up selling your stock, actually, and you lose your interest in the company. So you own 100 shares of Microsoft. You can't pay a creditor. They get a judgment, then go garnish Microsoft, and they sell your shares. That's also true of very small companies. And when small companies go to sheriff's sale, they don't fetch a lot of money. It's a different rule for LLCs. If you own 100% to 1%, doesn't matter, of an LLC and a creditor gets a judgment against you, they can't go garnish the company. Well, they could, just won't do any good. They get what's called a charging order. And a charging order is an order directed to the company that says, hey, look, when cash comes out of the company, you don't give it to Phil, you give it to Phil's creditor. And this is where Arizona's in the minority, that's the only thing the creditor can do. That's their exclusive remedy. That's the only thing they get. So, Put yourself in this place. You're running your company. You got 10 employees. Things are going along great. You end up in an automobile accident and you didn't buy the umbrella policy we told Ty and Austin told you to buy several weeks or months ago. And you know, you've put a neurosurgeon into a wheelchair and you've got this huge liability that you now can't pay. But you've got this company and you've got employees and you know, you kind of like to earn a living that way. Well, they can't take the company away from you. They can get this charging order. So you're running your company and it makes money every year, but the creditor only gets a piece of that if you decide to distribute it out to yourself. So how often is that going to happen? I mean, sure, I could write a check to myself for $100,000, but then I have to write it to the creditor. Maybe I won't do that. And so what it creates is a stalemate. Where the creditor can't get to it, you've got some options as to what you can do with it. Sometimes it's a loan. You can, if you're not an S corporation already, you can take a salary, which is 75% exempt. So there's ways to work around it, but LLCs are a whole lot better if you end up with personal liabilities unconnected to the business, because they can't take them away from you. Again, Arizona's a minority on that. Nevada's the same way. Delaware, South Dakota, Wyoming, and I think there's one other.
Unless you file personal bankruptcy.
Unless you file personal bankruptcy, in which case federal law applies, they're going to take it all away from you anyway. So don't do that.
I was going to
Whatever you
ask,
want.
if you own real estate personally and they have mortgages on them, are you allowed to move those properties into LLCs to protect them along with the
It
mortgage?
depends on your mortgage documents. I'd say frequently if you're the owner of the LLC and you know, because some mortgage companies, if you're in real estate, you know that some of them have what's known as due on sale clauses, which trigger if you're selling the property, you got to pay off the mortgage or something. But if you're just transferring it either to an LLC that you own or a personal revocable trust for estate planning purposes or something like that, typically the banks will either waive that or else the language of the agreement will accept that out from the due on sale provision.
Okay. Thank you.
Yeah, times out of 100, the loan's going to say you can't do it. But if it is really a transfer from you to you, it depends on your mortgage company. But a lot of them will go, yeah, we really don't care about that. We had a question back here.
Just a quick question. As an owner on the real estate aspect, so if you have rental real estate, are you a fan of having an LLC for each particular rental unit?
That depends.
That's a good question, actually. That's a good question because
It depends. What are the
I own personal opinion, but
three? Is it
multiple homes, multiple single-family homes.
okay? Here's the problem that everybody in that situation faces. The right answer from a liability standpoint is to put every unit in a separate LLC. The problem with that is that beyond 3 or 4 homes, it is a royal pain in the backside.
it becomes unwieldy.
Because you got 4 companies, right? So you got 4 bank accounts. You may have 4 taxpayer ID numbers. You have to do 4 sets of bank reconciliations. You have one landscaper who goes out and mows the lawn at all 4, sends you one bill. How do you pay that bill?
Right.
Do you pay it out of one? Well, now you're paying from one to the other and you're disregarding the rules. And over time, that administrative inconvenience causes people to stop paying attention to the rules, and they buy a dishwasher here and they put it in that house, and the structure collapses. Well, not literally, but it effectively, you lose the protection because it's such a pain in the backside. So my rule of thumb is generally if you got 3 or 4, put it in one entity. That's not perfect. Buy extra insurance and then follow the rules for that entity. If you get to 20 homes, I'm not sure what you do. Do you have a staff? Do you have somebody who really likes keeping all those details straight? I mean, that's the tension. That's the trade-off. Now, if it's a 60-unit apartment building, a 200,000 square foot retail center, and 600 acres of raw land. Yeah, put those three things in three separate entities. You're going to live with that. But if it's $300,000 homes, people generally are happier if they put them in one entity.
I will make an exception to that, and that is if you've got one that is, really highly leveraged or is kind of your weak link, maybe you had some vacancies and it's the one that, looks like it might, go upside down on you or something.
Rent to ASU students.
In that instance, you might want to segregate that, that weak sheep from the herd and put it in its own company.
Right. What about having a management company that's a separate entity that all four of the others pay to manage? So your landscaper, et cetera, is covered by the management entity, and then
That works as well. And
Okay.
for people who are good with keeping their administrative details in line, that's a good solution. Yeah.
so it's way higher. Higher rate.
Yeah.
Anything else?
Okay. Well, thanks.
Thank you for coming. I just want to point out, November 14th, we have a presentation on basically branding necessities, IP, intellectual property issues, and things of that type. So if you're going to have a business, you're going to have a product, you may want to come and learn a little bit about how you protect that property.